I want to begin by saying that the justice system is an entire ecosystem. It is not just about the courts. There will be no time at all when the courts will be sufficient in resolving our disputes. To answer your question, whether Kenyans have embraced alternative dispute resolution, in fact, if you asked me, Kenyans rely on alternative dispute resolution on a day-to-day basis to resolve their disputes. It is only in exceptional cases that people go to court. In fact, the research we conducted last year at the Chartered Institute of Arbitrators, and I have the privilege of being the chairman of the Chartered Institute and serving on the task force that rolled out the court-annexed mediation in the judiciary. It's a task force led by Justice Ochieng. We have been around for about 8 years. What we noticed is that about 92% of disputes in this country are resolved by alternative justice systems. Only about 8% of cases are resolved in court.
92 is a big number.
And that 8% is what you are now saying has created a backlog. Imagine if the justice system, with all its financing from the state, can only carry 8% of our disputes and still be overwhelmed. What is it that the ADR sector is doing? The ADR sector is actually the driver of justice in this country. It is what carries the load, the alternative justice system itself. So what has happened, and what my sister was talking about, is the recognition of the ADR within the formal justice system, so that the courts are now giving impetus, giving access and assisting it. Now, this is a matter which, as my sister has said, is not a question of an option. Kenyans in the Constitution of 2010 commanded the judicial system to promote and actively ensure that ADR is used in resolving disputes.